Hello, my name is Mark Monlux, and this is Law and Artist, episode number 2, where we're going to be talking about U.S. Code and Article 17. But first, a disclaimer. Law and Artist is a discussion on general principles of law and art. Nothing in this vlog or subsequent postings should be construed to be a substitute for advice of counsel regarding the specifics, facts, and circumstances of an individual case. Laws and their interpretation differ from jurisdiction to jurisdiction. Legal advice addressing a specific situation should be sought from an attorney duly licensed in the appropriate jurisdiction.
Could not have said it better myself.
Thank you, Daniel. Why don't you introduce yourself?
My name is Daniel Abraham. Used to work as an illustrator. I've been in legal practice for 25 years, and I handle copyrights, trademarks, and related intellectual property law. And we are here now to discuss the U.S. Code. Why would we want to do that? Because the U.S. Code contains Title 17. Title 17 is the copyright law, which governs the transactions by artists, by designers. And last time Mark and I spoke, we discussed the necessity for a written agreement between the artist and the client. The U.S. Code, Title 17, governs those things. It is the overarching sky under which we all work. Now, the current version of Title 17 was passed back in 1976. It took effect in 78, and it governs. It determines how copyright comes to be. It comes to be now when something is fixed in tangible form. Now that sounds very legal. What that actually means is you draw something, you fixed it. It's in tangible form. There's a piece of art, and therefore you've got a copyright in it. That's true even if what you've drawn it on is your computer, not a piece of paper. Now, once that happens, you've got a copyright in it, but that copyright is totally unenforceable unless and until you register it. And Mark, you've registered a number of your things, have you not?
Oh yes, I definitely have. And part of the reason I've registered things is it's an ethics thing. And people talk about the decline of ethics in modern society. And here's the thing is most illustrators and graphic artists are doing poor ethics, because here's a situation. A client comes to you and they say, hey, someone's using the logo that you designed for me. What can we do? Unless you were the one that went out of your way to go ahead and license that artwork, or pardon me, not license, but to file for copyright for that artwork, to register it, your first course of action has not been taken to protect the client. In order to protect your client, you need to, on any work that you do, register it for copyright. And then you're going to be much more thoroughly protected.
Well, you want to protect the client. You also want to protect yourself. Had a client a number of years ago. The client was a design firm. They had done a whole series of logos for a pretzel company. They had done actually more than one series because they had offered several different design families of logos to this company for, I don't know, 10, 15 different kinds of pretzels. And what happened was the company stiffed them. The company decided to pay them less than they'd agreed to pay for the things they actually took. Then they took a second one of those design structures and said, oh, we're going to use this too. You don't like it? Too bad. Sue us. Go ahead. Now, if the design company had registered the work for themselves before transferring it to their end client, then they would have been in a much better legal position to be able to enforce their agreement against the client that was actually refusing to pay them for the stuff that it had done. Understand, you cannot enforce a copyright unless it has been registered. You got it, but it's like a car that's up on blocks. It doesn't go anywhere. You can't go into court without that magic certificate that says you have registered the copyright, you are the author of the work. So you need to have that to enforce it in any way, shape, or form. More important, you need to have it registered before somebody else steals it, because otherwise you lose two very important things: statutory damages and attorney's fees. Statutory damages are damages that are determined by the court under the statute. It's like Simon Says, but this is statute says. It's, you know, the statute says you can get up to this amount of money, whether you can show damage or not. It doesn't matter. The court can do it anyway. And if you can show that the other side said, we know you own it, we don't care, and that makes it willful, not just accidental, not just stupid. If they say, we are using this despite your ownership of the work, then the court can increase the damages to a major extent. Excuse me a moment. Thank you. Anyway,
Daniel,
now,
I have a question.
What
My question is going to be about the U.S. Code and how it originates, but finish your thought, please.
Okay. Well, basically, what I want to point out is that there are two things you get: statutory damages. But wait, there's more. It's, you know, the real Ginsu knife in this is the ability to claim attorney's fees, which Mark and I will deal with in another one of these episodes. But you cannot get attorney's fees unless and until you have not only registered, but you've also got to have registered before the other side has infringed the work. It's got the registration has to be before the infringement, or you cannot claim attorney's fees at all. And attorney's fees can be very expensive. They are a major impetus to the other side to settle, because they may be willing to pay their attorney in order to fight you. They don't want to have to pay your attorney to fight them. And so that's a very important thing to be able to claim. Anyway, your question, Mark.
Yeah, I think that yeah, our next episode should be about attorney's fees. I agree there. So I have this question. The U.S. Code, we mentioned it, but a lot of people don't understand or don't even know what the U.S. Code is. Can you? It's easy to find on the website once you know how to type in, you know, look for the U.S. Code. But Daniel, can you explain what the U.S. Code is?
Well, the U.S. Code is the body of law that the federal government has passed that covers everything the federal government does. Now, you don't have to worry about all of that. You can tell from the fact that that the copyright law is Title 17 that there are a lot of sections of the U.S. Code. The one that deals with copyright, Title 17, is on the Copyright Office website in its entirety. With the Copyright Office website being www.copyright.gov, that's G-O-V, gov as in government. And there is a section there. You can read the entire thing yourself. It's actually for law in fairly plain language. And if you find that difficult, there are a lot of circulars there that explain the stuff much more simply than the code itself does.
Now, I accidentally...
Does that help?
Yeah, that does immensely. I accidentally used the instead of saying Title 17, I said Article 17. So it is Title...
No, Article 17 sounds very constitutional. It's Title 17.
Title 17.
Yep.
Well, I think we got about... I think we have about 2 minutes left. I want to quickly let people know that please post further questions to Daniel and myself about contracts, copyright law, any type of questions that you think you might have regarding how to sell and license your work, or more specifically, what to do in a situation that you're unsure of. comments in the doobly-doo below. Also, you'll be able to find contact information for both Daniel and myself. I'm an illustrator. I used to do a lot of design work, but now I just mainly draw a bunch of cartoons. So, Daniel, what else can you say about Title 17? It really does talk about everything about copyright. Everything is really covered in there, including, you were mentioning the last change to it was in 1976. That had a lot of things.
The last major change. The last major change. Remember, this is Congress.
Yeah, I was going to ask you, did the Millennium Copyright Act, was that enacted into it?
No, well, the Digital Millennium Copyright Act is, that's a whole topic unto itself. But that was added a relatively few years ago. And what that does is it provides on the one hand, a safe harbor for internet service providers, and that, to explain all of that's going to take another set of minutes. But basically, it provides a way to get something infringing taken down just by sending a demand to the service provider. This is something we'll have to go into in greater detail in the future, I think.
Okay.
Okay.
Yeah, I think that's a great idea. Just to remind people, just adding a copyright symbol in front of your work is not enough. That's pretty much the equivalent of a keep off the grass signs legal-wise. You really need to register your copyright.
Mark, actually, I'm glad you mentioned that, because I would like to say that the copyright notice, which you just mentioned, see in the circle, your name, the date, lovely thing, beautiful thing, very useful for proving willful infringement, which can be very lucrative in court. But by itself, without a registration in back of it, it means absolutely nothing. Absolutely nothing. It is the registration, not the notice, that gives you the muscle in this situation.
Thank you for your time, Daniel, and I look forward to seeing everybody next time.
Yep, it's been a pleasure as always, Mark. Talk to you soon.